Hi, my name is Galaxi Wilson. I'm a freshman at Appalachian State University, and today I will be discussing medical malpractice claims for Law 2150. Medical malpractice is the improper, unskilled, or negligent treatment of a patient by a healthcare professional. A common misconception is that an unhappy outcome to a surgery or procedure qualifies as medical malpractice. The key factor to a medical malpractice case is negligence. Negligence is a failure to behave with the level of care that someone of ordinary prudence would have exercised in the same circumstances. Being informed is extremely important in regards to medical malpractice in dealing with healthcare professionals. Because of the high risk associated with any type of surgery, it is imperative that the patient is aware of what to do if something goes wrong. Many people believe that medical malpractice does not occur very often, but it is a leading cause of death, which is absurd because it can be avoided in many cases. At some point, we will all need to utilize the medical field and healthcare professionals, so it is important to be knowledgeable and safe. In order for medical malpractice to be at hand, there are three elements that must be met. The first is a violation of the standard of care. There is a certain standard for healthcare professionals that must be held at all times. If this standard is not met, then negligence by the professional may have occurred. The second element is an injury caused by the negligence. The patient must prove that the violation of the standard of care resulted in an injury. Without this, there is no case. The final component needed to be shown is the injury resulted in significant damages. This includes damages such as pain, suffering, disability, or issues related to medical bills. These three components are extremely important when proving medical malpractice has happened. On average, as many as 225,000 people die each year from medical malpractice. It is the third leading cause of death in the United States. Only 15% of cases filed involve medical malpractice, and more than 80% end with no payment. Over $3 billion was spent in medical malpractice payouts in 2012. Medication errors harm 1.5 million people in the U.S. every year. OBGYNs have the most common occurrence of medical malpractice. They hold 19% of cases alone. The cost of medical malpractice nationwide is about $35 billion. And the statistic I found to be most upsetting is that 12,000 deaths occur each year due to unnecessary surgeries. In our contemporary society, changing our bodies to make a more perfect figure is not unusual, and plastic surgery is a measure that many people take to reach these standards today. If people were aware of the amount of deaths that occur due to unnecessary surgery, the need to change our bodies would probably occur much less. Patients who are informed about medical malpractice will think twice before undergoing unnecessary surgeries, which in turn would bring down the number of deaths per year due to medical malpractice. These are trending legal issues for medical malpractice cases in North Carolina. A 27-week premature infant was placed on top of a plastic saline IV bag that was overheated in a microwave oven for 10 minutes, which resulted in severe third-degree burns. The shock of these caused hemorrhaging and meningitis. This left the infant neurologically devastated. A suit was filed against the hospital on the basis that the healthcare professionals were negligent for punitive damages. Initially, the hospital denied negligence, but later accepted liability. The family settled the case before trial for $9 million. In another case, a young boy at Wake Forest University Baptist Medical Center in North Carolina was experiencing avulsions in his nerves after a tree limb fell on his shoulder. He was given heparin, which is a blood thinner. Shortly after, his caretakers discovered bleeding in his spinal cord. Due to concerns about his long-term stability, they decided to perform a procedure in which a halo device would be installed in the child's head. While installing this device, the surgeons penetrated the skull on accident, causing a rip in an artery and a hematoma. This in turn caused deep strokes, infarcts, permanent brain injuries, and neurocognitive deficits. The case was taken to trial in the Forsyth County Superior Court, and after 4 weeks, the jury returned a unanimous verdict for $10.4 million. These are statutes of limitations for medical malpractice cases. A medical malpractice action must be brought within 3 years from the date of the last act of the defendant, or within 1 year of when the injury should have been discovered, but no more than 4 years from the date of the last act of the defendant giving rise to the action. If the medical malpractice claim involves an object that was left inside of the body, the defendant must bring action within 1 year from the discovery of the object, but no more than 10 years from the date it occurred. If the medical malpractice claim involves wrongful death, action must be brought within 2 years from the date the death occurred or the time bringing action for bodily injury. The legal issue I focused on is medical malpractice caps. State legislators have passed medical malpractice liability caps in lawsuits. These caps limit provider liability. Under this legislation, the caps usually allow unlimited recovery for economic damages such as medical expenses. The caps place a limit on non economic damages such as pain and suffering. There is a lot of debate on whether non economic caps are actually effective or not. Reform advocates argue that medical malpractice improves costs, improves the quality of care, expands access to health care, and is more equitable. Others against caps on medical malpractice argue that it encourages physician misconduct, and many states have adopted caps, and what they are set to varies by the state. Typically, states cap non-economic damages at $250,000. According to the U.S. General Accounting Office and National Association of Insurance Commissioners, tracking the effects of tort reforms on medical malpractice is impossible. Non economic and economic damages cannot be distinguished, and therefore estimating the impact of caps cannot be done. In a study done by the U.S. Department of Health and Human Services, premium increases in states with non economic caps of $350,000 or less were 72% lower than states without caps. In a study done by the California Institute of Technology, damage caps may reduce the quality of care due to an increase in the frequency of injuries by negligent medical care of healthcare providers. On the other hand, a study from the New York University Law Review suggested that if non-economic damages were capped, attorneys defending plaintiffs would attempt to prove more economic damages, which would in turn result in higher jury awards. North Carolina has a cap set at $250,000, but there is an exception to this cap reform in North Carolina on the basis that two necessary elements are met. These are that the plaintiff must have suffered disfigurement, loss of use of the part of the body, permanent injury, or death, and the defendant's acts of failures, which were the cause of the plaintiff's injuries, were committed in disregard of the rights of others, grossly negligent, fraudulent, intentional, or with malice. Many state appellate courts have found non-economic caps to be unconstitutional because of a violation of the patient's rights. Limiting non-economic damages is said to restrict the patient's right of due process and equal protection and right to trial by jury and access to the courts. Patients are said to be classified in product liability cases, which can be discriminatory. The classification between patients whose damage exceeds statutory caps and those whose damages do not can be considered discriminatory and therefore unconstitutional. Patients that suffered damages which exceeded the statutory cap were selectively denied full recovery, which violates the Equal Protection Clause. So basically, patients argued that denying those who suffered injuries that exceeded the statutory caps was discrimination because the most serious injuries were restricted in compensation under these caps. Smith v. Department of Insurance was a case that occurred in Florida. The plaintiff argued that the $450,000 cap, which was enforced by the 1986 Tort Reform and Insurance Act, violated the Florida state constitution, which says that the courts should be open to every person for redress of an injury, and justice shall be administered without delay. The court concurred that this violated the right to access of the court. After extensive research and consideration of several legal scholars on the issue of medical malpractice caps, I found non-economic caps to be both constitutional and effective when set at a low cap. When set at no cap or a higher cap, they seem to be less effective and do not achieve their actual purpose, which is to limit compensation for punitive damages. States with a $250,000 non-economic cap experience losses that are 45% lower than insurers in states with no caps, which confirms that higher caps do not improve insurance or lower losses. To further my support in this opinion, a study done by the Risk Management and Insurance Review showed that states with caps set at $250,000 for non-economic damages show significantly lower loss ratios. A non-economic cap has a consistent positive relation with lower losses compared to states with higher caps, proving them to be ineffective. To summarize my research, there are 5 important points to remember. Medical malpractice is the improper, unskilled, or negligent treatment of a patient by a physician, dentist, nurse, pharmacist, or other healthcare professional. There are 3 elements necessary to prove medical malpractice. These elements are a violation of care, an injury caused by negligence, and an injury resulted in significant damages. In the upcoming world today, countless surgeries both cosmetic and medically necessary, occur every day, it is vital to be informed of the risk associated with procedures, as well as the rights we are entitled to if something goes wrong. Many states have passed non economic caps. These caps limit provider liability. Under this legislation, the caps usually allow unlimited recovery for economic damages such as medical expenses, but they place a limit on non economic damages such as pain and suffering. It is critical to be informed of medical malpractice and our rights and responsibilities as individuals. This brings up the question of what to do if medical malpractice occurs. We are entitled to compensation for damages, so there are many things you should do to prepare yourself if medical malpractice occurs. You should contact a seasoned attorney and secure all medical records. You should write down all pertinent information and find out procedural requirements that are needed before a lawsuit can be filed, and always be aware and informed. These are my references.